Hey everyone, it's Ryan Zomorodi. I'm a real estate investor and wholesaler who's been in the game for over a decade, and I've been doing deals all over the country. I'm also the COO of Real Estate Skills, where we train new and experienced investors to build profitable wholesaling and house flipping businesses all over the nation. In this video, I've invited an active, licensed real estate attorney and owner of a leading law firm in South Carolina to thoroughly discuss the topic, is wholesaling real estate legal in South Carolina? There's a lot of buzz around the new South Carolina wholesale real estate laws that recently passed with House Bill 4754, and specifically a lot of misconceptions about what wholesaling in South Carolina means after the enactment of this law. To help you understand what's really going on in an unbiased interview and to help wholesalers who are impacted by this law, I've invited Bryan De Bruin to help get to the bottom of this matter once and for all. Bryan is an attorney of over 10 years and partner in De Bruin Law Firm, a reputable and well-established law firm that facilitates hundreds of real estate closings in South Carolina every single year. Bryan and his team have been hard at work studying the ever-changing laws since they heard about it, and they've created unique solutions that no one else is talking about, which are completely in compliance with the current landscape. Not only is Bryan at the tip of the spear of the changing legal landscape in South Carolina for wholesalers, he's also one of the most accomplished real estate investors that I personally know. He's an active real estate developer who's doing everything from buying and entitling raw land to developing subdivisions and new construction townhomes to syndicating deals to buy, renovate, rent, and sell apartment communities. He also owns multiple businesses in the real estate industry, and he's doing so much more than that. So unlike other attorneys out there who don't actually engage in the practice of real estate, he brings a wealth of knowledge from being an actual investor who has wholesaled, flipped, and really has done everything in between. I'm absolutely thrilled to have Bryan join me today to dive into this topic to discuss the state of wholesaling in South Carolina and the new laws affecting wholesalers in the state. Bryan, I couldn't be more grateful for your time and doing this for our audience today.
Absolutely, Ryan. I really appreciate you having me on. I think it's a really important topic, not only if you're in South Carolina actively, wholesaling, investing in real estate, participating in it, even if you're an agent, to understand what this new change really means. But if you're looking to come into our market as well, I think going in with eyes wide open as to what it means to wholesale now in South Carolina is going to be important to protect yourself, protect the transaction as well.
Absolutely, couldn't agree more, Bryan. So why don't we just start with you sharing a little bit about your background in law as well as in real estate. I'm sure our audience would love to hear why you're particularly qualified to be talking about the legalities of wholesaling in South Carolina.
Sure. So I am a partner at the De Bruin Law Firm. I've been a practicing attorney for about 10 years now in South Carolina. Primarily, my practice focuses on transactions. So estate and succession planning, business law, and then real estate, being both commercial and residential. With that, I'm also, as you mentioned, a real estate developer and investor myself. I own and manage a couple of real estate and private equity funds. We manage a little over 700 residential units in South Carolina, over 200 individual properties. So we buy, we sell, and on the transaction side, we certainly represent both developers, flippers, wholesalers, and everything in between. With that being said, a primary focus of our firm on the residential side is catered towards investors, and that is everything from someone who's doing the next 1,000 home community to deliver lots to a national home builder to someone who's buying their first flip. We believe that we provide a product and a service unmatched in that we can take you from the initial concept, forming your business, to your transaction, and then as you're getting used to it and your business is growing, all the way to the succession plan for how you're going to leave that money to your family and forever benefit everybody around you.
Yeah, that's fantastic. It's really such an invaluable resource, seeing things from the very beginning of an investment all the way to the succession planning. I mean, that's incredibly great, and just brings really the full spectrum perspective on real estate and what it can really do for people long term. So I appreciate you sharing that, Bryan. So let's talk about what South Carolina did to codify real estate wholesaling. With states like Illinois, Pennsylvania, and Ohio creating restrictions around assignments of contract, South Carolina is one of the only states that actually defines real estate wholesaling. So how are they defining it in the law? It'd be great to just unpack this newly added language into the bill.
Yeah. So first, I mean, I think that's a really good point. Other states have tried to slow down or curtail wholesaling. The way that South Carolina has done it, it is a clear and evident intent to kill wholesaling in the state. And I think if you take it for anything other than that, you're doing yourself a disservice if you want to still engage in the practice of investing, either finding ways to continue to run your wholesale business or to purchase wholesale property. I think you have to read this with that in mind, that the intent is to actually kill wholesaling. And by that, I'll go through essentially the definition in and of itself to start with. Wholesaling means having a contractual interest in purchasing residential real estate from a property owner, then marketing the property for sale to a different buyer prior to taking legal ownership of the property, advertising or marketing real estate owned by another individual or entity with the expectation of compensation falls under the definition of broker and requires licensure. Wholesaling does not refer to the assignment or offering to assign a contractual right to purchase residential real estate. That definition has a lot in it. And I think to start and going back with the framework in mind, saying, if you take what I'm saying, at face value, which is the intent is to kill wholesaling, and then we unpack this, I think you'll see kind of where we're going with this. First and foremost, the definition of wholesaling, why it's so important. By defining it this way, which is the marketing of property that you have a contractual interest in. Right there, that puts it into a separate category that goes really to the meat and bones of how most wholesalers operate. I find a distressed property or an opportunistic property, a single family home. I engage with the homeowner or the seller. Maybe it's a probate deal, a tax sale, something, and I put it under contract. Typically, then what happens is I have either an email campaign or a social media campaign or just a general Facebook or some other social media audience where I'm sending that information saying, hey, I have a 3-bed, 2-bath in this location, looking to sell it for this amount. That right there is what they define as wholesaling in this. It is the marketing of that property when you only have a contractual interest in it. And then the carve out that they put that I think gives everybody a little bit of pause. And in the beginning, I think there were some folks that thought that there was a workaround to this when it says wholesaling does not refer to the assignment or offering to assign a contractual right to purchase residential real estate. A lot of people have taken the position that I just need to put a disclaimer then saying I don't own the property and therefore I can now wholesale. That's just not the case. Wholesaling is the marketing of property in which you only have a contractual interest in. Cut and dry, that's what they're doing. And they're not saying you can't do it in this paragraph. They're saying that's what it is. And then they're saying you need to be a broker in order to do it. And this is where I mean that they're trying to kill wholesaling. The very clever way that they've done it now is that by having it be a licensed approach. So before, 5 years ago, 2 years ago, if you wanted to put that property under contract, put it out on Facebook, and someone came to you, they certainly could say, hey, you need to be a licensed broker to market it. Your position would be, I have a contractual interest in the property, therefore I'm allowed to advertise that. So instead they said, okay, we can't tell you not to do that. Instead, what they're going to say is, in order to do that, you have to be a licensed agent. Now, essentially, they have jurisdiction over you. If you go out and become a licensed agent in South Carolina, in order to comply with this statute, as a step one, that might make sense. However, as you read further down in the statute, you'll get to licensed agents are prohibited from wholesaling. Pretty cut and dry. They're actually prohibited not only from wholesaling, but assisting in or engaging in a transaction involving a wholesaler as well. So that is a very clever way of saying the first thing we're going to do is claim jurisdiction over you. You have to become a licensed individual to engage in this practice. And then once you're licensed, any licensed individual can't perform this act. That intent is not to regulate, as you've seen in other states. That intent is to kill wholesaling. So I think everybody should kind of look at it from that point of view. And the reason why I'm so strong on that position is if their intent is so clear, eventually there's going to be regulation on it. I think right now, if you go on the social media channels and groups, you see that people are still actively engaging in this definition of wholesaling. Sooner or later, I think if the intent is to kill it, you will see some sort of enforcement of this.
Yeah, absolutely. Absolutely. No, that's a great breakdown of it. So I think what's interesting, as someone who's worked in other states, one of the initial things that I think about is, hey, the contractual interest gives me as the wholesaler some form of a legal interest in the title of the property, which then I can go market and sell and monetize that interest. And there's something in contract law that defines the equitable interest. And typically that's been seen as the main way forward for a lot of wholesalers. But in this case, what are your thoughts on that? It seems like it's pretty clear that it says a contractual interest is, which is then marketed, is considered the definition of wholesaling, right? So that workaround does not seem to apply in this situation. Is that right?
So I think it's 2 points. One, everything you said I think is exactly right. When you have a contractual interest, the belief has always been, and I think it still holds true, that you have a right to sell that contractual interest, being an assignment agreement. There's nothing in here. In fact, going back to that last definition, wholesaling does not refer to the assignment or offering to assign a contractual right to purchase residential real estate. They've made it very clear to say that you have a contractual interest. You have the right to sell that contractual interest. The only thing that they've tried to outlaw, or at least put into this box, is the marketing of the contractual interest. And at this point, again, I think they've drawn a line in the sand and said, how far can we go? And we can go up to the sales and marketing because there's a public benefit. And what I mean by a public benefit is, whether you agree with it or not, the position by South Carolina and many states is that wholesaling disadvantages really 3 groups: the elderly, minorities, and those in distress situations. It's this belief that because the property is sold for a value lower than what would be considered market value, that somehow they have been taken advantage of or they've been given less than. It doesn't take into the account that there's other factors in every transaction, not just real estate, that dictate price. One is convenience. If someone's willing to close in 7 to 10 days, why wouldn't I give them a cheaper price? 2 is closing costs, which I don't think that anybody wants to say out loud, but by going the wholesale route direct to seller, oftentimes you're leaving commissioned agents out of the deal. And I think the real estate commission putting their hands on this is a clear sign that that is affecting their revenue. So there's other factors, as everybody in the investment space knows, that dictate price other than just, I want the highest price. So, there's a saying, you can have your terms or you can have your price. I think that applies throughout, and I think it applies in real estate as well. So I don't think that that's accurate, but that is at least the public policy position that they've taken is what this is meant to protect by requiring the license. Now, with all of that to be said, I don't want to be too doom and gloom, because I think that there's very clear business strategies that everybody should take a look at, and there's clear carve-outs here that I think everybody should take a look at. The first being the definition of wholesaling. Wholesaling means having a contractual interest in purchasing residential real estate. So this same section in this same code defines residential real estate as improved real estate, so having a structure for a 1 to 4 unit. So that could either be a duplex, a triplex, a quad, or a single family home, 1 to 4 units. Therefore, what wholesaling does not cover is vacant land, commercial real estate above 5 units and more. Those are not considered to be wholesaling per this definition. So with that being said, if it's not wholesaling and you get that piece of property under contract, you get the vacant lot under contract, and you go back to your main social media sources and the other pool that you're selling to and advertising and marketing to, per this definition, that's not considered wholesaling. So I think that's important to note. So now we've kind of painted it and put it into a much smaller box than all wholesaling is dead in South Carolina, to say Single family homes between 1 to 4 units where the intent is to, where the possibility is to be a primary occupancy is considered residential. Residential real estate is what falls under this wholesaling definition and category. And then from there, what are the workarounds? What are the business strategies that you should be taking to continue to do business, but also to protect yourself and the transaction?
Yeah, I think that's a really important point to make, because there is a very clear definition that they've put out there. And if you're able to operate your business outside of that definition, then technically you're not wholesaling as defined by South Carolina Real Estate Commission. So wholesaling can mean a lot of different things to a lot of different people. And so they've kind of cornered one specific way of going about wholesaling, which may not apply to how one wholesaler might actually run their business, right? In the case that you just mentioned, if you're wholesaling non-residential real estate, which in this case is 5 units and up, right? Larger multifamily properties, vacant land, right? If you're wholesaling to developers or land investors, as well as anything that's, non-residential commercial real estate. So none of these restrictions would apply if you're, contracting and then publicly marketing, those types of properties, obviously within certain, certain limits. Is that correct? So,
yeah, it is. And I think it's, going back to the public policy component, if you take the commission at face value and kind of the drafters of this statute at face value saying their interest is in, those 3 public interests, then I think you can kind of play devil's advocate and say, okay, so they narrowly defined what wholesaling is to really only protect, those that would be in that situation. So I think there's some back and forth there. But I do think it's clear based on this definition that they've done very specific things to carve a very narrowly tailored definition. While it may not seem narrowly tailored, it is to what, constitutes wholesaling, and therefore what requires a license that ultimately is then prohibited if you are licensed.
Yeah, absolutely. And so kind of on the second part of the definition, they prohibit licensed agents from even participating in wholesale transactions, right? Maybe even not as a principal, but even as an agent. So, are there any sort of consequences to that, or is there kind of any blurry lines as it relates to agents, right? How's an agent going to know if their client is now attempting to assign the contract via Facebook Marketplace, or if they're publicly marketing it? What are some of your thoughts as far as how they've prohibited agents from even having anything to do with a wholesale transaction as they define it?
Yeah, so the short answer is I don't know how this is going to affect agents because it seems extremely unfair to me if I were an agent in a transaction. And by that I mean the definition and the changes clearly state that agents are prohibited from wholesaling. So that one, okay, we understand that one. But they're also prohibited from engaging in a transaction with a wholesaler or assisting in a wholesale transaction. So the definition or the example that you've given, I think, is really the concern. If I'm an agent and my client asks me to list the house, I list the house, I put it on MLS, it goes on to public forms, and someone submits a contract and offer to me, my client signs it and accepts it, right? And in there, they put an amendment that allows them to assign it. Assigning it is not wholesaling. I have a duty and obligation to provide that amendment to my client, advise them as necessary. But again, those agents are not attorneys, so they shouldn't be really advising us to the legality of certain things. But it's clear assigning contract is not wholesaling. So they haven't violated anything yet. Now the buyer has the right to assign it. And the buyer on their own goes and markets it with a contractual interest for sale. That buyer now has engaged in wholesaling per this definition. And per this code, the agent now is prohibited from being involved in the transaction. So if the interest is public policy, if it's a public policy interest in which we want to protect the public, well, now you've put an agent in a pretty difficult position. Either they violate the statute and stay in the deal, or they raise their hand and say, hey, I cannot be a part of this transaction. You now have to represent yourself, seller, client, which now have you committed some form of malpractice? I don't know, but they essentially have to remove themselves from the transaction, which can't really be a public interest if sellers no longer have agent representation. It's kind of a catch-22 for the agents. So back to my answer, I don't know how it's going to affect agents because it just doesn't seem fair. And I don't know how an agent could possibly police the actions of a buyer in that scenario either.
Absolutely, yeah. It seems like they obviously want to make a statement. They may want to encourage action, but the practicality of, regulating this to a micro degree of every transaction seems very difficult, and kind of curious how they're going to actually implement it.
I agree. I don't know how that one goes at this point. It's we'll see.
For sure. And I also wanted to point out that when they state advertising or marketing real estate owned by another individual or entity with the expectation of compensation falls under the definition of broker requires licensure, that hasn't changed, right? That's always been there. Nothing about that has changed or affected anything. So they just kind of threw that in there as almost a reminder. Is that right? I mean, that's always been the case. That's always been a licensed activity.
So what has always been the case is, yes, marketing real estate that you don't own with the expectation of compensation requires licensing. That's been the case. But it's always been the belief that if I had a contractual interest in it, now I own a contractual interest, I therefore have the right to market my contractual interest. That is what they've come back and said. And in some, you might be watching this and saying, hey, that's splitting hairs. And in some cases you could be right. But that's their position. Now, the contractual interest is not enough for you to be able to market the property. If you own the property, if you owned it, had an equitable interest in it, then you could market the property without violating this wholesale statute. And so that kind of goes into what are the possible solutions for continuing to do business without running afoul of this statute. And so one of the ones that's been floated more often than not now, in South Carolina, we have a couple names for it: bond for title, contract for deed, land installment contract, but they're all essentially the same thing. They are a contract to purchase real estate in which that contract is recorded at the Register of Deeds and it is paid in some form of installment. So for example, that single family home, if I were to put it under contract with a bond for title and it said, I'm going to give you $1,000 now, and I'm going to give you $1,000 a month for the next 99 months until I've given you $100,000, that would be a bond for title. And what that creates is the minute it's recorded, even though I've only given you $1,000, the minute it's recorded at the courthouse, I have an equitable interest in the property. That equitable interest is much larger than a contractual interest. I therefore now have a right to market the property. So everything I just said about what is wholesaling goes out the window. I go back to Facebook, I go to whatever group or email campaign, and I send it out and say, I have a 3-bed, 2-bath, looking to sell it for this amount, or best offer, or whatever that campaign looks like. And I am perfectly fine to do that because I have this equitable interest. And the Supreme Court of South Carolina has been pretty clear on their opinion as far as equitable interest goes, that they hold it in a high regard. And so while that seems like a very good solution, there's a lot of pitfalls to bond for title, land installment contracts, specifically on the title side. And I'll give you a couple examples as why we as a law firm don't like seeing them, and when possible, we advise against them. So the first one would be, I'm the buyer again, it's a $100,000 house. We agree to this $1,000 initial payment. We record the bond for title, and me as the buyer, whether I'm trying to essentially flip the contract or buy it myself, I don't find an end buyer or I don't come up with the money, whatever the case is, and I never make the second payment or the third payment. You as the seller have an expectation, and a lot of times that seller has an expectation that, again, they're selling for less than top dollar because of convenience or time. So you expected to close in 2 weeks. Well, now I don't have the money or I don't have the end buyer, and you can't get a hold of me. and you say, okay, he hasn't paid me the second one, I'm going to go find someone else to sell it to. The problem with that is you now have what we call a cloud of title or a defect of title. There is a third party, me, this old buyer, who is defaulted on his terms, who has recorded a document, an instrument, and an equitable interest against your property. That now has to be resolved before you can sell it to someone else. And so what's the solution to that, right? It's not an eviction process, which maybe takes 30, 60, 90, 120 days, depending. You have to go through the foreclosure process because you're foreclosing on an equitable interest. So just the timeline to serve me with that paperwork, and then I have 30 days to respond, you've now created a 30-day minimum timeline. Up to typically, a foreclosure can take anywhere from 6 months to a year. So as the seller, with $1,000 in your hand, you've given up a year for what you were trying to sell, really for convenience in a timeline that made sense to both buyer and seller. So there's a ton of title issues that come up in land installment contracts. So what we've done is we've said, okay, we recognize that South Carolina puts this emphasis on equitable interest, that the equitable interest theory says that we can now market and sell this property if I have an equitable interest. How do I make it a situation in which the seller isn't left holding the bag, and that we have these multiple clouds of title on folks that, typically want to sell in a relatively short period of time and who don't want to be inconvenienced. So now we don't want them to be doubly inconvenienced because a deal falls through. So for us, we've modified the traditional land installment contract to put it more into investor language, to create some automatic reversions for sellers, to give the escrow agent some rights to record some automatic satisfactions in the event that buyer doesn't live up to the contractual rights. They go away, and now we have this cloud of title. Someone needs to be able to fix that relatively quickly. And in our case, if we're the closing attorney or the escrow agent, both parties are going to give us the right to do that and make that decision. With that being said, that is not a perfect solution. It is not ideal. I would much rather have someone have it under contract, not perform on the contract, and now we just have a non-performance contract as opposed to clouds of title on real estate. But that's the landscape kind of we're working in now.
Yeah, absolutely. On the surface, it seems like a pretty easy solution. I know there's some people talking about it right now, but there's clearly some pitfalls and some risks for both sides, right? As the buyer, you can enter into this contract. As soon as you record it, then now you have that legal interest to then go and market it. However, you don't have that time to do your proper due diligence on title. What if there's liens that show up? What if there's back taxes? There's a number of things that can come and affect the deal. And then vice versa on the seller side, if the buyer is unable to perform, now you have this encumbrance, which could take months, over 6 months potentially to clear. And to your point, if they've only received $1,000 to cloud their title and potentially not be able to sell the property, then that puts them in a difficult situation. So I love that you've been able to innovate and your firm has been able to really take a look at this whole situation and, given the landscape, create some safeguards to this method, right, the land contract route to navigate this scenario. But even with those protections, it's still not perfect. So,
and it's going to put more of an onus on the buyer too, to educate their seller on what this land installment contract is, as opposed to a traditional real estate purchase and sale agreement. So, how buyers, how investors navigate that is going to be difficult also. And then the second part of it is the actual closing. So kind of going back to that scenario, I give you an installment contract for, it's a $100,000 installment contract to give you $1,000 up front. I take the risk of incurring those costs up front, but I do find an end buyer. Well, now we have to move into a double closing scenario. So as an escrow agent, you might find some escrow agents that do this, but I promise you they shouldn't be because it's illegal. As an escrow agent, if I'm the buyer, that escrow agent has to use my funds to close on the transaction for your property. What they cannot do, and they should not do, is use the end buyer's funds to close on the transaction for your property. So if it's $100,000 to just $99,000 to close on it, and I'm selling it for $120,000, they cannot take that end buyer's funds, apply it to mine, pay you, give me the difference. That is a misappropriation of funds. The only way that they can do it is that end buyer has to sign off on essentially loaning me the money. Now, if you want to go that route, we've done it in the past, but now everybody's kind of full disclosure. There's loan agreements that are going on, and I'm satisfying a mortgage or a loan at closing when I turn around and sell it to the end buyer. The benefit of doing the double transaction, though, is you don't have to worry about assignment fees. They want to buy it for $120,000. They're getting a deed for $120,000. Their lender is loaning on a $120,000 purchase. So a lot of some of the things that come up in assignment deals that make it difficult to get things across the finish line, they don't have to take place. But that middleman, that middle buyer, they have to come up with their end of the money, either through themselves or through a third-party lender. We have transactional lenders who loan funds for a day that we work with. So the money goes in escrow and out of escrow, pretty much the same day. So there's workarounds like everything else in business to it, but now there's an added cost. So this land installment contract, while it gives you the equitable interest up front, you have upfront costs that a lot of wholesalers traditionally haven't had to have. You got to put something down. You have title costs that are more upfront. You got to know if there's deed issues and title issues prior to closing that you're going to be on the hook for. And then you have some sort of transaction cost that you otherwise wouldn't have had if you were just assigning the deal. So those are, increased costs. And with any regulation change, there's typically always increased costs across any business. Real estate's no different. So while there are good things as far as working through this statute and this code by getting an equitable interest, there's also, pitfalls as well as increased costs and difficulties. So with that, there's another approach that we use often on the commercial side. And the statute has made it very clear that you're allowed to do as well, which is the assignment. The assignment itself is not a violation of the wholesale law. It's really only the marketing of the property, when you have a contractual interest in it. So for us, one of the ways that you can do it, and we've done it before, and I think it'll continue to happen, is instead of marketing the property, you would market the LLC that owns the contract in the property. We'd call that an asset purchase agreement, or in this case, an assignment of membership interest. So what that means is I go and get that same property under contract for $100,000. I form an LLC. I assign that property to the LLC, which I'm allowed to do by this statute. It's not considered wholesaling. So now the LLC owns the interest in the property, the contractual interest. And instead of marketing the property, I go and I market my LLC for sale. So I have this LLC for sale. It's got a contract to purchase something for $100,000. I think that contract, which we would call an asset, is worth $100,000. I think it's worth $150,000. So now I'm going to market my LLC for $150,000. Whoever wants to buy my LLC buys all of its assets. And that's how we do it all the time on the business transactional side. It's a tried and true method. And per this code, that is not a violation, in my opinion, of it, because you are simply marketing what assets it has. And it might be that it has 5 properties under contract, which makes, it more valuable. It doesn't have to be a one-to-one exchange, but typically we've designed it to be a one-to-one exchange. And so process-wise, if I could just go through that a little bit, I put it under contract with you. I go to the law firm, say, hey, I want to put this and assign it to an LLC. The law firm forms a simple limited liability company in South Carolina with a single member membership operating agreement. And on top of that, if the goal is to essentially sell the LLC, they will then have a templated assignment and sale of membership units for you as well, and a contract to do that. So now you would go and market it, and you would say, I'm going to sell the LLC for $120,000. There's disclosures that you would put in there stating that this entity, which would be in the operating agreement, is a single purpose entity, or an SPE. What that means is in the operating agreement itself, it says this entity was created for the purchase of, and then you would list the reasons why. And so if it's for the purchase of 1 property, 2 property, 5 properties, whatever it is, you could define those, and you can make it very clear to your buyer, your end buyer, what it is that they're purchasing when they purchase the LLC. And again, it's a newly formed LLC. And then at closing, that buyer would be purchasing your LLC in one of 2 fashions. Either they would purchase it prior to closing and then they would close on the transaction, or you would purchase the property and then sell the LLC with the property deeded to it already as a double closing, which again would still require transaction costs and a double close, or you could assign the LLC prior to closing. I know that was a lot.
Yeah, no, that's fantastic, Brian. Makes total sense, and I'm following. So I kind of like to categorize these solutions into 2 buckets. It sounds like, the first one with the installment contract, that's more of, hey, establishing a legal interest in the property. And once you do that, you can now market, advertise, and wholesale because you have that legal ownership. The second bucket is avoiding advertising the property or contract. So this way, now you're not doing that. You're actually advertising the LLC, and the assets of the LLC include the purchase agreement, which just so happens to be tied to a piece of real estate, right? So that way you're not falling into that definition. You're not marketing a contract or property. You're now marketing the LLC. And so you can still open up the marketplace for your deal. I'm just kind of curious, how do you generate interest, right, for an LLC? I think in the wholesaling industry, it's a little bit, it'd be a little bit extraordinary to see, hey, LLC for sale. So I guess first question is, hey, how do you market it to find a buyer? And then the second question is, how do you protect the buyer? How does the buyer protect themselves from any potential, liens or existing debt on that LLC? How are they supposed to know if there's anything else attached to that LLC when they purchase it?
Yeah. So the first part would be how to market it. You would market it like any other business, where, it's 123 Main Street LLC. This is what it owns, and it would be the contractual rights to purchase property at 100 Main Street, 200 Main Street, and however many other properties you wanted to add to it. And then you would have some sort of distinguishing summary of the properties themselves. Would be one way that you could go about doing it. And for us on the legal side, especially on the transactional side, we do not recreate the wheel. So every time we are giving some sort of advice, we're saying, where is this already being done? And, the most common way that this is being done actually is when it comes to builders, and they're being bought by national home builders. So if you're being bought by D.R. Horton or Ryan Homes and you're a builder, one of the reasons why you're being valued and the valuation on your company is how many lots you have under contract. So it's the same mechanism. So instead of how many lots do I have under contract, it's how many properties or houses do I have under contract when I'm selling this LLC. Now, it doesn't matter if I've owned the LLC for 10 seconds or 10 years in that transaction either. Now, going back to the end buyer, how can they be protected? That's where it becomes, like everything else, there's pitfalls. And in this case, there's pitfalls to that as well. If I were to form the LLC today and 6 months from now, put a property under contract, I think you as the end buyer should and would have some concerns on what have I been doing with that LLC for the last 6 months. And yeah, we can have agreements where I indemnify you for any harm. We can have me fill out an affidavit saying that I haven't done or transacted with this, but it always comes down to trust at that point in time. And what's the level of trust that end buyer wants to give? If it was me, it would be, especially if a first time transaction, it would be very little trust. So how do we reduce that? Well, one of the ways that you reduce it is you have the law firm form the LLC, hold the documents essentially in escrow, and as the organizer of the LLC, they can still form it And before transferring essentially that organizational rights to the initial buyer, that should all be a simultaneous aspect of closing, or as close to as possible. So if I put it under contract today, I got to close in 20 days. I want to go through whatever due diligence I feel necessary, whatever title I feel necessary before I engage third parties, however long that needs to take. And then I want to put it into that LLC. I don't want to create bank accounts. I don't even want to get an EIN at this point in time. And as the buyer, by doing things like that, the investment buyer, by doing those things, you now can start to certify that you've done it via this process. And then at closing now, that buyer is going to have a little bit more, and in most cases, a lot more certainty that transactions haven't taken place if this was formed 10 days before closing, not 6 months. And so the more you can shorten that window, the better off you are. But ultimately, it is like everything else, it's a game of trust. So you're going to have to know who that investor is to make sure that there's not issues that come up later on.
Yeah, absolutely. That makes sense. And keeping it streamlined, keeping the timelines tighter, and then kind of doing it all in-house with one firm, which is, why I think it's great to bring you on, because your firm does specialize in this. They can form those entities very quickly. I believe you mentioned last time we talked, 24, 48 hours in a very short amount of time at a minimal cost. And so being able to streamline that can circumvent any potential issues, or at least help build that trust, of course, along with some indemnification agreements. But at least that can overcome some of the objections of, hey, what have you been doing with this LLC for the past, 6, 12, 18 months? I don't know what's going on in this LLC. So at least it's a little bit more of a clean slate when you do sell or assign the membership interests of that LLC to the end buyer. So I think that's a really great solution.
Yeah, and in this scenario, I don't know if there's a perfect solution, because every transaction has issues, and has the transaction itself might not, but the process by which you're doing something, there's always going to be a way that something bad can happen, or there can be an issue that comes up. And so the job really of the transactional attorney and the parties involved is, what can we do to logically mitigate as many of these issues as possible? In some cases, we're playing the insurance game by how much risk can we reduce. So on this case, we feel that the LLC transfer and sale has a lot less risk and a lot less title concerns and future concerns than the land installment contract.
Absolutely, and it's a little more straightforward because now you're still dealing with a purchase agreement, and I think most buyers and sellers are more familiar with your standard purchase agreement than with an installment contract, and especially with some of the variations on it, the protections. It's probably a tougher sell at the end of the day when you're dealing with a distressed seller who is probably already struggling to make the decision to sell in the first place. So I think just the more straightforward it can be, the more likely you are to actually get that deal under contract, at least just in my experience. So this way you can still work with purchase agreements. It's a lot more relatable, understandable, a lot more following a more traditional process, but now you're just simply having to form this special purpose entity, and then now you're selling that entity for a profit, and that contract never actually gets assigned. Or maybe it does, but you're not marketing to find a new buyer and then assigning it to a new buyer at the end of the day. So that sounds a lot cleaner. Yeah.
Yeah. And then look, the third one that we've seen, and I think that there's some positives to it, is that joint venture approach. And again, it goes right to the heart of this, which is to say, I'm just not going to market it. I'm going to establish some existing relationship with a house flipper or end buyer ahead of time before I even find a property that makes sense to me. And I think it's harder to do it that way. Certainly. I think that affects, what that investor's ROI is going to be on the money that they're spending for lead generation and everything else. But I've seen that as well. And then, this is kind of our opinion as a firm, and I have not seen, and maybe it'll be updated with the state bar, but I have not seen it yet change. But our job is to take a purchase and sale agreement and to ensure that the terms of that purchase and sale agreement are adhered to, and that the title, passes in a way that purchase and sale agreement says it should. So if it's a general warranty deed with clean title, unencumbered, then that's our job. It is not our job to then go and do an investigative, research on how the parties came to be about whether this was marketed or not. And I don't think it would be reasonable for our firm or any firm, whether it's one person at a firm or 100 people at a firm, to have to research whether or not someone violated one aspect of South Carolina's Real Estate Commission, unless it was put into our face. So with that, we still certainly close real estate in which there's assignments. Happens on every single commercial transaction, maybe 99% of the time, in which our commercial client has put a property under contract, whether it's a multifamily apartment or a piece of land that they're going to develop, and they're going to put it into an SPE or another entity prior to closing, and we're going to handle that assignment. That is a completely legal, valid, and approved way, an appropriate way to handle a transaction. And it is, from a liability standpoint, the way that we would always suggest. So with that being said, if it works for a triple net lease, QT or some other commercial property, it should also work for a single family home to us. So with that, if a flipper wants to assign that property to a third party entity that they own or have a partnership in or don't own, that assignment is not outside of the binding of this law. That is expressly stated that you're allowed to do that. The only question is the marketing of it. And so for us, we just simply have an affidavit that just says that you haven't marketed the property if you have a contractual relationship on it. And that's it. Because again, it's not our obligation, in my opinion, to go into research whether or not you have marketed the property, and if you have, to what degree you have done it or where you've done it. I know other firms have taken different approaches. Some just don't do any assignments, but I think that the assignment aspect of it is a right in South Carolina to assign real estate, and it's one that is a right by good reason, because it's got a lot of legal benefits to that purchaser.
Absolutely, yeah. I think I like to remind a lot of wholesalers that assignments of contract are very common in real estate transactions. So it's not like they can just ban assignments, because it's a very, normal and common thing that happens with real estate contracts. So I think it's just they're defining it a certain way. And so I love that you're able to bring these strategies, these concepts, that some of the highest level real estate investment companies, development companies use on a regular basis, and can apply it to the humble single family home property that, just the mom and pop kind of wholesaler is transacting. And so I think it goes back to your point that they are trying to protect, certain interest groups that are, potentially being affected by wholesaling in general. But there are these strategies that are implemented really even at the highest level that can be ways forward. And so I love that we're able to apply it to this situation as a means forward.
Yeah, absolutely. And I think, as this continues to go, I think there will be an evolution of how investing in real estate, and how, while maybe traditional wholesaling changes, the interesting thing is wholesaling would not be a business venture if there wasn't clearly a need. That's kind of how capitalism works. Where there's a need, someone's going to come and find a solution for it. And wholesaling happens to be the solution for people that want, more convenience. They don't want to show the house 20 times. They don't live in the area. They've inherited it. They want to sell quick. All of these different reasons why people engage in a contract with a wholesaler. There's a very clear reason for it. And I think the underlying principle is that transactions and investment will continue to happen. And now everybody will just have to kind of do it a little bit differently in certain scenarios.
Absolutely. No, that's a great point, Brian. Yeah, wholesalers serve an important place in the whole real estate ecosystem. And I mean, speaking from experience, like there are sellers who prefer to sell to a wholesaler just because they know
Yep.
they can get the job done without having to, clear out their entire house, and they can get help with moving costs. They don't want to put it on the market, pay those real estate commissions. So there are a ton of benefits in working with, cash buyers, with wholesalers, just from the speed and convenience of working with someone like that. So
Absolutely.
there's definitely a need.
Yep.
So I absolutely resonate with what you're saying.
Yeah. I mean, I've both purchased and sold through wholesalers, and it's been a good experience every time.
Yeah, absolutely. You've been on both sides of it. So let's really dive into that third method, the JV agreement method, the partnership agreement method. I really like this one because it aligns with what, how I've structured my wholesaling business, for most of my career, as well as what we teach here at Real Estate Skills, about building relationships and, having true partnerships with our end buyers, and not just focusing on blasting a contract to 1,000 buyers that you've never even talked to, but more about forming authentic, true, and more long-term relationships with a small handful of buyers that like, and trust, and that know, like, and trust you as well. So why don't we dive into the JV agreement method?
Yeah, absolutely. So the JV agreement method, JV is short for joint venture. Kind of just backing up what a joint venture is. Again, similar to everything else we've talked about, joint ventures are a common practice, both in small businesses all the way up to Fortune 500 companies. They engage in joint ventures all the time. So there's a couple of reasons why you would have a joint venture. But to start, it typically means two or more entities coming together, not as a partnership for a long period of time, but as a partnership for a specific purpose or a short period of time, or both. Some reasons why you would do this. Let's say that you had a roofing company and I had a shingle company, and I sold shingles. We might come together with a joint venture agreement for a marketing campaign, where now we're going to pool our resources, and instead of sending out 5,000 mailers, we're going to send out 50,000 mailers, because we get a benefit. The more mailers we send out, the less cost it is per mailer. That would be a joint venture marketing campaign. We'd sign an agreement that says how this cost is going to be proportioned, who's going to pay what, when the call comes in, how is it going to be handled? Maybe my staff handles the initial intake, your staff handles the sales, all of these things. So while we're not a partnership in the traditional sense, where we're operating a business with a long-term strategy, it is for this very short period of time. So that's one example of what a joint venture would look like. In this space, it would be similar in that, let's say that I am a traditional wholesaler and you flip houses. It might be to my benefit to find an end buyer, someone who I already know has the capital and the resources and the desire to purchase real estate ahead of time. And then it might be a benefit, because you're busy flipping the house, to have someone who's actively out finding the next house. And rather than you going and hiring someone, or me having to go and find capital to purchase the house myself, we form a joint venture that says, okay, I'm going to actively pursue finding homes because I want to be in this space, and that when I do find those homes, that you're going to purchase them, and I'm going to have some costs up front to purchasing the home, and maybe you reimburse me at or before closing, but I'm also now a partner in the project. When I exit, that project is up to you and I to decide. Do I exit it at closing? Do I exit it at completion? Do I exit it when you finally sell? How am I paid in that transaction? Do you just give me a flat fee? Do you give me a percentage of profits on the back end? All of those things are the agreement itself that you and I come to, but the structure of it is very simple, that in this specific standpoint, we are going to be aligned if these things happen. If I find a property, if you like the property, I'm going to assign you the property, and now our joint venture for that property and project begins. And then when it ends is also defined. Doing it that way takes out the entire marketing concern right then and there, because as soon as I get it under contract, I already know who's buying it. My partner's buying it. And so there's not a market component to it. and I'm not marketing it for a fee either. So I'm not running afoul of this brokerage component either. I'm putting it under contract with my contractual interest, and then I'm assigning, which I'm allowed to do, my contractual interest to either a joint venture LLC that we both have some interest in, or an LLC that we've agreed that we're going to assign this to for liability reasons or something else. So all that to be said, one of the easiest ways to do it is we would work this out ahead of time. I get the property under contract. We would essentially solidify per property that, hey, yep, this one works for you. This is a great opportunity for you to flip this house. You like the numbers. And then I would assign it to either that joint LLC or your LLC. And we would essentially use the joint venture as our playbook for how this deal is going to play out and how this limited partnership for this limited period of time for this limited project is going to play out. And if it works, great. And maybe that, you didn't make enough money or I didn't make enough money. And we say, this joint venture didn't work. Well, you don't have to do anything other than just not do it again. And so that's one of the benefits of the joint venture approach. Like everything else, though, there's hurdles that you have to overcome. And the first one to overcome, which I would see it more as an opportunity, is that if you are the traditional wholesaler in this space, it is imperative that you find trusting, reliable end buyers that you can partner with and essentially engage in that practice with ahead of time before finding those properties. And it could be something as simple as, Ryan, this is what I want to do. If I were to find a property that meets these standards, would you be willing to pay me X for it in some form or fashion? And if that's the case, then we can memorialize that in agreement. You're not bound to do it. I'm not bound to bring it to you. I could buy it myself if I wanted to, but we've at least said if these things check the box, this is how we're going to do this agreement. I think doing it that way, at the end of the day, if you're in that wholesaling space and you're trying to sell to end buyers, the worst thing that happens, and I've seen it happen, is that you get someone who doesn't actually have the money or flakes on the last second. And you ruin your relationship with that seller, you ruin your relationship, or financially you've paid money out of pocket. There's a lot of downside to that. So again, establishing those clearly defined relationship goals and partnership goals through the JV agreement, I think is a net benefit to that traditional wholesaler.
Yeah, absolutely. I love this method because, it encourages that relationship. It encourages getting very familiar with this buyer's investment criteria and understanding what they believe to be is a good deal. And so that way you're not just putting properties in your contract that you believe to be potential deals. Like, you should be able to know with confidence that this is a great deal based on your particular joint venture partner's investment criteria. And so it's really what we've been teaching here at Real Estate Skills. If you see any of our other videos, we always teach finding the buyers first and truly vetting them and building relationships with them. And so you have some kind of predetermined agreement or relationship, and then this takes it a step further and really puts it in writing so that there's something that's very clearly defined. And this way you're not going to market the contract to find an end buyer. You already have a pre-existing relationship with someone who's going to be investing in the property. And I also love how creative you can get with the joint venture too. I think a lot of wholesalers, they just focus on, hey, I want to get paid up front. I just want to make a fee right at closing or right at the time of assignment. And so this promotes creativity to where, hey, maybe instead of just getting a fee up front, maybe you're getting a profit participation in the deal. If it's a fix and flip or it maybe even a buy and rent, then at least you can get creative with how you're going to participate in the joint venture. So that now you may be able to get some of that profit as well, and really start building that track record too as a wholesaler, or maybe it's a combination of those things. So I think that it's a great opportunity for wholesalers to expand how they're able to even monetize on these deals and get even more flexible and creative with how they're working with these partners at the end of the day.
I completely agree. The other thing that happens too in real estate, as you know, there's kind of levels to it. And one of the benefits of being in that wholesale space is that you can enter. The barrier to entry is pretty low, and if you find the right joint venture partner, you can really learn. And so a lot of things that I've seen folks start on that wholesale side and grow to, I'm flipping houses. Now I'm buying a 1 to 4 unit, BRRRR method. Now I'm buying an apartment complex. Now I'm developing, a community. I've seen it multiple times. And one of the things that always surprises guys in the beginning is when you go to get that first loan on that fix and flip, if it's not, a friends and family or a private loan, the first thing that they're going to ask you is, what's your track record? How many have you done before? How many have you been a part of? And great that you've sourced 10 deals before this, but if you've never actually been in the flip, if you never walked through the house, when you brought it to studs, that's not a great look for that lender. But in this case, like you said, if you're, staying in the deal in some portion, you get to, in sincerity, put on your track record, I've done these as well. Now, maybe you don't have much of a project management role in that, but you're still in the deal. And it starts to build a lot of credibility when you're going to your lending partners as well, because you've actually seen it from start to finish. So I think, like you said, I think the flexibility on the joint venture approach is fantastic. And I think it creates a lot of opportunities to just work through it. The best way that I've seen it done, at least in my opinion, for those that have kind of taken this method, is, instead of having 100 people that they're just throwing spaghetti on the wall and hoping someone likes this house that they have under contract, they have it dialed in to say, I know Bob likes, 3-bedroom ranchers in this price point, and him and I have a joint venture agreement. So I know every time I get one of them under contract, he's my partner every single time. And I know, Cindy loves, townhomes and, condos and scattered sites, and she's my partner, and we're going in and flipping that. And you really now start to dial in who your joint venture partners look like. And also, I think it helps as you're talking to that seller and you're saying to them, I have a buyer. I know who my buyer is. It's our partnership. And, it's not window dressing that you're telling them, because you've done it, multiple times. And, I think sellers hear that confidence. And I think, whether we want to admit it or not, they can kind of determine and you kind of hear out who's done this before and who hasn't, who really has the ability to close, who hasn't. I think that sincerity means a lot when you're kind of going through this conversation, especially if you're cold calling or going direct to a seller who, again, wants to sell for some sort of reason other than the highest price.
Yeah, absolutely. I mean, building that trust, building that rapport is so important, especially when you're working with distressed sellers, to be able to, like we, in our business, we refer to our end buyers as financial partners, because we really do see them as partners. We want them to succeed. We want them to be making money too at the end of the day, so that they can come back and continue to do business with us and not lose their shirt over a bad deal that we tried to squeeze every dollar out of. And I think it's interesting because, this isn't like a new concept, this joint venture partnership agreement. This is something that, even very large investment companies who are buying, hundreds of houses every single year, they have acquisitions people or acquisitions arms who are independent of their company who are sourcing deals to them. So, and they have some sort of a JV agreement with these individuals. They're independent contractors, and so, but they're getting rewarded for sourcing deals for these investment companies. So it's just, doing it at a little bit of a smaller scale here with our mom and pop wholesalers, which is a lot of people in our audience who are listening to this. But yeah, like you said, it's really about building that track record too. So when you want to evolve as a wholesaler, you want to start flipping your own properties, you want to be buying rentals, having that track record is really key, so you can prove that you've been a participant in these deals as well, and not just earning assignment fees at the end of the day. And even logistically, as you've mentioned, it's something that you can assign these contracts to your joint venture partner for maybe $1 or maybe $0, and ultimately you can invoice them for an acquisition fee, a marketing fee. We like to call it an independent consultant fee. so that you're actually getting paid directly from the buyer, and so it's not even an assignment fee at that point. So I think that that's also something that people can take note of and how they can operate. Of course, it takes that relationship, it takes some trust, but it is a way that even some of the highest level investment companies will operate, having these acquisitions type of individuals sourcing deals for their business.
Yeah, I mean, taking the lawyer hat off for a second and just kind of putting on the investor myself and business owner myself, I can tell you that I've seen it done both ways. I know there was a point in time where I was buying a lot from a wholesaler, and the position that we advocated to him was, let's go into a joint venture agreement. I want the certainty to know that I'm not going to have to compete in a 24-hour sprint on this house that you put under contract with 50 other guys, 49 of them who can't come up with the money anyways. And you should want to know the certainty I just bought 5 from you in the last 30 days that I'm going to buy the 6th. And I had that instance twice. And the first person didn't see the value in us, didn't see the value in the certainty to close. And what ultimately happened on their end, which I think happens a lot, is they just got burnout. They started putting anything they could under contract. Wasn't a good deal. They didn't really have any understanding other than an ARV model of what it should be, because nobody was willing to invest the time to go walk the property with them and tell them, hey, this is what I'm going to do with it. This is how much I'm going to make on the back end, and give them that kind of training, knowledge, and experience that I think would have made them better at negotiating the initial sales price. So they experienced burnout. They had a bunch of deals that couldn't close. They were putting a lot of money out, both in title work, due diligence, or just earnest money that was non-refundable. And they eventually left the space. And then we had another guy who essentially came to us before we could even get to him on the joint venture side. And his position was, extremely refreshing, which is to say, I want the certainty to know that if I bring you something in your buy box, you're going to buy it. And that you can buy up to X amount a month. And he put it on us to say, what is it can we afford? What is it that our buy box dictates? And then we sent it back and said, yeah, if it meets this criteria, this price point, we'll buy. At that point in time, we'll buy as much as you want to sell us. And away he went, because now on the back end, he had the certainty to know that there was a transaction to have as soon as he had this under contract. And I cannot overstate how powerful that is in a business relationship, to know that you already have an end buyer in hand. And while, you may want to go and, send it out to the market and get top dollar, that's great. But there's also a cost of capital and a cost of time on your end, where instead of finding the next deal, you're having to essentially haggle over all your disposition fee. So again, I think there's levels in real estate. And one of the things that oftentimes people forget is that there should be, and there's not, but there should be always a cost to their time associated with every deal. And if you forget that, you find yourself experiencing that burnout.
Yeah, couldn't agree with you more. Sometimes the certainty of a return or of a profit is worth sacrificing some upside because you're going to get it. And I think that's just case in point, having a very clearly defined criteria, a buy box, and a committed buyer that you've vetted. It gives you the confidence to go out and do more volume, knowing that you have a consistent end buyer. So couldn't agree with you more. It's what we've been preaching here at Real Estate Skills for a very long time, and how we like to run our own businesses as well. And it kind of ties into a variation of this joint venture agreement method that we like to teach here, that I like to call the acquisitions associate method, which is basically just having that agreement with a buyer or multiple buyers, but ultimately you have them go on the contract from the get-go, and it's their LLC, it's their purchasing entity who contracts on the property. And then if they close on that deal, right, it matches their investment criteria, matches their buy box. If they close, then now you're earning your marketing fee, you're earning your consulting fee. And so there's no assignments, there's no marketing to find the buyer. And so, in my opinion, it kind of lands right into where this is a way forward, given the landscape, especially in South Carolina, but even in other markets, having that relationship to where you can put the end buyer right on the contract from the get-go, it can avoid some of the friction with assignments or just having to question, hey, do I need to put up this earnest money deposit? And is this person going to close? Now the responsibility, that liability of the contract is on the end buyer too. So it's just another kind of variation of this whole thing. Of course, you lose some control, but in exchange, you kind of get that certainty. If that buyer obviously performs, then now you can be sure that they close. So just wanted to kind of throw that in there.
Yeah, and I think people are always surprised how little the other side knows what they're doing, or the extent to what they have to do. I think sometimes flippers and buyers like myself get into a bad habit of not understanding how many no's that investor or wholesaler has to go through to get to a seller that's willing to sell, how many bad deals they have to underwrite to get to a point where this is worth purchasing. And there's a cost to that. So I think that the joint venture method allows you as that wholesaler or investor to talk to that end buyer, earnestly and say, this is what I do to get this under contract. This is how many calls I have to make. This is how many times someone has to hang up on me. So many times I get yelled at for calling after 4 p.m. All of those things, I think, again, educating, your buyer, which your flipper, your end buyer is your buyer, they're your customer, and that component is a net benefit. And a lot of times there's this kind of almost, I see it sometimes where there's a lack of transparency on the assignment fee. And that's where things kind of get to confrontational and friction starts to arise. And you don't want to get there because, again, you want that end buyer to trust that you're bringing them a good product, that you're bringing them a good project and a good deal. And oftentimes communication builds trust more than anything else. These joint venture agreements are great ways to template out how we are going to communicate. What's that cadence going to look like, which ultimately builds trust. And where trust is, there's confidence, and there's just more business to be had.
Absolutely. I know there's also a lot of buzz around, subject to, and how, some people are saying that that's a solution. I know you do have some thoughts on sub to in general, and particularly in this situation. Of course, that's a way of gaining legal title to a property, but any thoughts on how that applies to wholesaling in South Carolina?
Yeah, so first, just defining subject to. I will tell you that, number one, our firm does not do subject to closings. And the reason why is, defining a subject to is, let me preface that because we do not do residential subject to. And the reason for that is a subject to mortgage is, again, if I'm going to buy that house for $100,000 and there's an existing mortgage for $50,000, I'm going to buy it subject to that loan. So if we agreed at for $100,000, there's a mortgage. So at closing, I'm only going to pay you $50,000, and now I have a mortgage on it for $50,000. That would be your normal subject to purchase. The issue with that is almost every residential contract or mortgage has what we call an acceleration clause. And the acceleration clause is pretty simple, that when title changes, when you sign a deed to me, that mortgage accelerates and it becomes due and payable immediately, which requires you to pay it off. If you don't pay it off, you've breached your contractual obligation with your lender. As the closing attorney, it is our job to make sure that title passes cleanly. So certainly, knowing that there's going to be an existing mortgage from a title side, we can handle that. However, every closing attorney knows or should know that there's an acceleration clause in pretty much every residential contract. Therefore, unless that lender signs off on me, the buyer, assuming that loan, then you have breached your contract. And there's a difference between just breaching a contract and knowingly breaching a contract and then knowingly misrepresenting the terms of the agreement, which is me continuing to make the mortgage payment. It is our opinion, it's my opinion, that the subject to method is at the least misrepresentation but probably more likely fraud and mortgage fraud. And therefore, as an attorney, barred and licensed in the state of South Carolina, I have an ethical obligation not to assist in the practice of mortgage fraud. So we don't do it. All of that to be said, on the commercial side, we do assignment closings all the time for mortgages, agency-backed non-recourse loans for commercial property. It's very common. I'm going to buy this apartment complex. I'm going to assume the existing loan. The caveat of that is the lender signs off and approves it. That's a big difference. But in the subject to realm for residential real estate, nobody's notifying the lender. In fact, which I think is more evidence of the fraud nature, they're going the opposite way. They're putting, the property into trusts because the trust is a workaround and doesn't trigger the acceleration clause. If I were to put my house into a trust, that doesn't trigger the acceleration clause per federal statute. Therefore, in this scenario, I'm going to form a trust. You're going to deed it into the trust, and then I'm going to take ownership essentially, or be the administrator of the trust as a workaround to that. I think that probably is more evidence of the misrepresentation and mortgage fraud than anything else. And so, I know me saying this on a recorded thing, there's going to be a lot of people that listen to other guys that are going to say, I'm an idiot. I don't know what I'm talking about. I do this hundreds of times a year, make millions of dollars. I get it. But I also remember when I used to work at the state's attorney's office, we had two different box retailers. One, if you shoplifted from the store and you were arrested, they would not show up to court, which made it very hard for us to prosecute those cases. And that person essentially would go away without any penalty. The other would show up and testify, and that person who shoplifted would face criminal charges and criminal fines and penalties. Just because someone's not showing up to say that you're doing something wrong doesn't mean you're not shoplifting. So just because the bank hasn't stood up and said, hey, this is wrong, we're going to do something about it, doesn't mean it's okay. Doesn't mean it's not a misrepresentation. Doesn't mean it's not fraud. If it were me personally, I would be concerned that if I got to a point where I had a number of subject to properties that I owned, especially in 3% interest rate market environments where I have this amazing deal and banks have issues with deposit accounts in which, they've either sold these loans on a market, or in some cases they still have those loans, I would be concerned that eventually an attorney general in some state is going to look at this and say, this might be something for me to go after. That's just me. Maybe it'll never happen. I don't know, but that would be my concern. So I know that was a long-winded way of me saying that we don't do subject to. I think there's also real world issues for that seller. It could affect some of their Medicaid, Medicare. It can affect that as well. It can affect their income. In the event that they wanted to purchase another home at a future date, they would be unable to do so because their debt to income ratio would be skewed because that loan is still in their name. In the event that the person who purchased it subject to stopped paying the mortgage, the bank would foreclose on the property, but they'd also be foreclosing against that seller. So there's a lot of real world things that also happen that are pitfalls outside of kind of the grander thing, which is how far in the gray is this, or have we just kind of gone out of it? So for those reasons, we don't do subject to.
Yeah, no, phenomenal answer, Brian. I think the analogy of, hey, you could operate in the gray and, it's a matter of, hey, are you going to get charged for it or not? There's a lot of risk involved, a lot of things that people might not be talking about for various interests, but yeah, people just have to realize, hey, there is risk, and you have to understand, are you willing to take that risk? And so some people may, and some people will be a little bit more conservative, especially when you're building a portfolio, you have assets on the line. When you're putting large down payments in, then those things could also be at risk. And then obviously, as you mentioned, the seller, there can be consequences if things don't go perfectly according to plan. It's great in theory, but there's a lot of reasons why a firm like Brian's, who does tons of investors, transactions, won't even touch subject to. So I appreciate you giving some insight into that, Bryan.
Yeah, absolutely.
So guys, we covered a lot today. There's certainly a lot to unpack. Really appreciate Bryan for joining us today. I know your time is extremely valuable. Where can people get in touch with you, Bryan, and potentially work with your firm on any types of closings in South Carolina, and any more information about working with you?
Yeah, absolutely. So we are located in Greenville, South Carolina, but we handle transactions pretty much every county, every municipality in the state. For, like I said, anybody buying a vacation home, single family home, all the way to investors, fix and flip, developers, and commercial real estate. So if it is a real estate transaction, we've probably done it, we've probably seen it. And then we like to be on both sides of, you as the investor, both your business side, how can we help put things in place to protect you? And then on the long-term side, after the transaction, how can we put the right estate plan in place to protect you and your family as you begin to grow? And again, from the estate planning side, I know we didn't get into this, but if you own property in South Carolina, you should be looking at, how would that property be probated if something were to happen to me, even if I live in another state? Those are a lot of estate planning questions. The utilizing trust to your benefit, especially if you're more buy and hold assets in the state of South Carolina, or really any state. Avoiding probate and avoiding the cost of probate as part of your succession plan should always be top of mind. So if you want to get in touch with us, myself or another member of our firm, you can do so. Our website is debruinlawfirm.com. That's DEBRUINLAWFIRM.com. You could also call us 864-982-5930. And then we'd be happy to sit down. If you're in the area, we can meet. If not, we can do it virtually and kind of talk about what your plans are, what your goals are, and how we can help form a strategy to get you there.
Fantastic, Bryan. And everyone, we'll link to debruinlawfirm.com in the description. So check out the description. You'll see a link to Bryan's website. Absolutely reach out to their firm for anything real estate related, estate planning related, any of your legal matters. He's obviously a go-to expert. He's our go-to expert here at Real Estate Skills in South Carolina. So it's very rare to have someone with as much experience really in every facet of real estate also be able to help you close transactions and really everything related to the legal side of real estate and estate planning. So again, Bryan, thank you so much for being a leader really in South Carolina with the ever-changing legal landscape, with a lot of just misunderstandings being floating around the internet. So I appreciate all the time. It's clear that you and your team have spent on really understanding the current state of wholesaling in South Carolina, and also providing real solutions and really the truth behind how people can actually implement a compliant strategy into their business going forward. So again, appreciate your time. Thank you so much for what you're doing for our industry and taking the time to chat with me today. So looking forward to chatting with you again soon, Bryan.
Absolutely. Bryan, I appreciate it. This has been great.
Wow, guys, what an amazing interview with Bryan. I certainly got a ton of value out of that, and I hope you did too. Bryan's time is extremely valuable, so that was an absolute masterclass for those of you who are looking to wholesale in South Carolina in 2024 and beyond. If you want to use customized contracts created by Bryan for the specific strategies we talked today, go ahead and click the link in the description to download our free contract packet so that you can actually get the exact documents that Bryan and his team have created to implement the strategies that we talked about today, including the land installment contract, the LLC assignment method, as well as the JV partnership structure agreement. Go ahead and click the link below so you can get this contract set directly emailed to your inbox so you can get started using these strategies today. For more information about working with Real Estate Skills to start, grow, or scale your real estate investing business, just go to realestateskills.com to learn more.